Welcome back to Lawyer Stories, the podcast where we delve into the intricate and often challenging world of legal practice. Today, we're going to explore a recent situation that our consulting company encountered through one of our long-standing law firm clients. It's a complex scenario, raising significant questions about professional conduct, the administration of justice, and the delicate balance attorneys must strike in advocating for their clients. This case, still unfolding, serves as a stark reminder of the broader implications our actions can have within the legal system. The narrative began with a construction accident, a common occurrence in the bustling metropolitan areas our client firms operate in. The plaintiff, an individual who had recently moved from the Rochester area to New York City, suffered significant injuries on a job site. Consequently, a lawsuit was filed, properly venued in Rochester, New York, where the incident occurred. As discovery commenced, a routine yet crucial step in any civil litigation, the defense counsel representing the construction company insisted on an in-person deposition of the plaintiff. This request, on its face, might seem ordinary. However, the location was specified for the Rochester area, necessitating a 6-hour drive for the plaintiff, who now resided in New York City. Plaintiff's counsel, quite reasonably, advocated for a remote deposition via Zoom, citing the substantial burden of travel, a common and accepted practice, especially in post-pandemic litigation. When the parties couldn't resolve this disagreement informally, a discovery conference was scheduled with the court. During this conference, plaintiff's counsel presented their argument to the judge, emphasizing the unreasonableness of compelling their client to undertake such a lengthy journey for a deposition that could easily be conducted remotely. The judge, in response, suggested an alternative, that the plaintiff could simply fly to Rochester. It was at this juncture, under pressure to explain the logistical difficulties, that plaintiff's counsel made a critical disclosure, informing the court that their client could not fly due to not possessing the necessary identification or papers for air travel. This phrase, while seemingly innocuous in a courtroom context, carries considerable weight when discussing an individual's legal status. Following this exchange, the court issued an order directing the deposition to take place, not in Rochester nor via Zoom, but in defense counsel's office in Newark, New Jersey. This decision, while shifting the location, still presented a significant travel challenge for the plaintiff, who would again have to navigate interstate travel. Despite the continued logistical hurdles and the sensitive nature of the information that had just been revealed, the deposition was scheduled and proceeded as ordered. The deposition itself, held in defense counsel's Newark office, was reportedly protracted. My client's firm later noted that defense counsel seemed to deliberately prolong the proceedings, covering ground at an abnormally slow pace. The day wore on, questions were asked, and answers recorded. As the clock approached 5 in the afternoon, the deposition was adjourned, left incomplete with the understanding that it would need to be continued on a subsequent date. This, in hindsight, would prove to be a pivotal detail. As the plaintiff exited the defense counsel's office building in Newark, a team from Immigration and Customs Enforcement, or ICE, was waiting outside. Without warning, the plaintiff was apprehended and taken into custody. The suddenness and precision of the action left little doubt in the minds of many observing this case, including our client's firm, that ICE had been specifically tipped off. The immediate and obvious conclusion drawn was that either the defense counsel or their insurance carrier had contacted ICE, using the information disclosed in court to orchestrate the plaintiff's apprehension. This turn of events immediately triggered a cascade of legal and ethical questions. Let's first examine the actions of plaintiff's counsel. Disclosing a client's immigration status in open court, especially when it's not strictly necessary for the immediate legal issue, is a decision that warrants careful scrutiny. While counsel was responding to a direct inquiry about the inability to fly, the manner of disclosure has been widely debated among legal professionals. Many argue that a more cautious approach would have been to state that the client could not travel for personal reasons, or that they lacked the specific real ID or requisite identifying documents required for air travel without explicitly mentioning papers. Such phrasing could have conveyed the logistical difficulty without revealing sensitive personal information that could expose the client to risk. The ethical rules governing attorney-client confidentiality, specifically Rule 1.6 in many jurisdictions, mandate that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized to carry out the representation, or certain exceptions apply. While explaining the travel burden might fall under implied authorization, revealing the specific reason related to immigration status, especially in a public forum, is a significant judgment call. It's often suggested that if such a disclosure is absolutely necessary, it should be done in a less public manner, perhaps through an ex parte motion or an in-camera hearing, where the judge alone would hear the sensitive information. Furthermore, in cases involving lost wage claims, a plaintiff's immigration status can become relevant for discovery purposes. Defense attorneys are often entitled to inquire about a plaintiff's ability to legally work in the United States, as it bears on potential future earnings. However, relevance for discovery does not automatically equate to open disclosure in court or the right to weaponize that information. Plaintiff's counsel could have advised their client to invoke their Fifth Amendment privilege against self-incrimination if directly questioned about their status, particularly given the potential criminal implications, even if immigration proceedings are civil in nature. This would have required a careful pre-litigation conversation with the client about the risks and benefits of pursuing a claim that might raise these issues. Now, let's turn to the actions attributed to the defense counsel and/or the insurance carrier. The strong inference is that they used the disclosed information to alert ICE. This raises profound ethical questions about the boundaries of zealous advocacy. While lawyers have a duty to represent their clients diligently, this duty is not limitless. It must be exercised within the bounds of the law and the rules of professional conduct. Many jurisdictions have rules, such as those in Illinois, Washington State, and California, that address attorneys threatening to report an opposing party's immigration status to gain an advantage in a civil dispute. The debate here centers on whether actually making the call without a prior threat constitutes an ethical violation. Some argue that reporting a perceived violation of the law, even if it benefits one's client in litigation, is not inherently unethical, especially if the information was acquired through non-confidential means, such as an open court proceeding. From this perspective, it's simply reporting a legal infraction. However, a strong counter-argument, supported by various bar opinions and model rules, asserts that such conduct, if proven to be orchestrated to thwart the administration of justice or intimidate a party, is indeed an ethical breach. Rules concerning conduct prejudicial to the administration of justice, like Model Rule 8.4d, are broad and often invoked in situations where an attorney's actions undermine the integrity of the legal process. The deliberate prolongation of the deposition, ensuring it remained incomplete, adds a layer of circumstantial evidence suggesting a calculated attempt to render the plaintiff's testimony unusable in any future proceedings, effectively making the case disappear without a definitive resolution on the merits. If the deposition remained open, the transcript, even if partially completed, would be less useful at trial should the plaintiff become truly unavailable. The timing of IC's appearance immediately after the deposition and outside defense counsel's office is highly suspicious. Deposition dates and times are typically communicated only between the parties, not publicly filed in a way that ICE routinely monitors. This points to direct communication from a party with knowledge of the schedule. Whether it was defense counsel, the insurer, or even the employer, who often has knowledge of their undocumented workforce to exploit them for lower wages, is a key question. The implications for the plaintiff are severe. He is almost certainly facing deportation, a life-altering event. For the civil lawsuit, his absence as a plaintiff will create an immediate and possibly insurmountable impasse. While a case may theoretically continue with an absentee plaintiff, securing necessary testimony, particularly for aspects like lost wages, which are often a significant component of construction accident claims, becomes exceptionally difficult. His past immigration status would also significantly complicate any claims for future lost wages. This strategy, if proven to be intentional, effectively removes the plaintiff from the legal process, benefiting the defense by making the lawsuit untenable. The court's role also comes into focus. The judge's insistence on in-person attendance and the suggestion of flying, followed by the order to depose in Newark, place the plaintiff in a vulnerable position. While judges have discretion, their orders must not inadvertently expose parties to undue risk or undermine access to justice. The question of whether the judge himself might have alerted ICE, though less likely in this context, has been raised in similar discussions, highlighting the pervasive concern about immigration enforcement impacting the judicial system. Our consulting company's advice to our client's firm on such matters always emphasizes a multi-pronged approach. First, securing immediate legal assistance for the client regarding his immigration detention is paramount, including exploring options like a U visa, which is available to victims of certain crimes who cooperate with law enforcement, although the backlog for these is significant. Second, vigorously investigating the source of the ICE tip is crucial. This would involve seeking a court order to compel discovery from defense counsel and the insurance carrier regarding any communications they had with ICE or other governmental agencies concerning the plaintiff's immigration status or location. While federal agencies like ICE are often resistant to state court subpoenas, establishing a record of attempts and the firm's lack of cooperation can be powerful leverage. Third, submitting a formal complaint to the State Bar Association regarding the defense counsel's conduct is under serious consideration, as arranging for a party's absence from the jurisdiction to influence the outcome of litigation may raise ethical concerns related to fairness and proper procedure. Even if there's no explicit rule against calling ICE, the overarching principles of professional conduct and the integrity of the legal process are certainly at play. This, coupled with the circumstantial evidence of the deliberately slow deposition, paints a picture of bad faith. This case is a sobering reminder that zealous advocacy must be balanced with fundamental principles of fairness and respect for the integrity of the judicial system. When the litigation process is manipulated to eliminate an opposing party through extrajudicial means, it undermines the very foundation of justice. For plaintiff's attorneys, the lesson is clear. Exercise extreme caution in disclosing sensitive client information, even under judicial inquiry, and always consider the potential ramifications. For defense attorneys, while the duty is to their client, the means employed must remain within ethical boundaries. The long-term reputational damage to a firm and its attorneys for such actions can be substantial, extending beyond any single case outcome. The ultimate outcome for this particular plaintiff remains uncertain, but the chilling effect of such events on future litigants, especially those without legal status who may fear seeking legal recourse for legitimate injuries, is undeniable. It creates a climate where access to justice is compromised for a vulnerable population, benefiting those who exploit them. That's all the time we have for today. Join us next time on Lawyer Stories as we explore another compelling case from the heart of legal practice.